Welcome to Chapter 2 of Law in Australian Society, which is all about case law. In this chapter, you'll learn about the second major source of law in Australia, in addition to legislation, the hierarchy of courts in Australia, the doctrine of precedent, which guides legal reasoning, and the meaning and importance of jurisdiction, which with legislation just meant the geographical area in which rules operate, but with case law it also means the authority of courts to hear different types of cases. What is case law? A case, also known as a matter, is when two parties, like sides or teams, come before a court to resolve a dispute. Cases are presided over by judges or magistrates, and at the end of each case, the judge or judges or magistrate writes up a judgment. A judgment contains the reasons for the judge or magistrate reaching that decision. Case law, also called the common law, refers to the collection of these written judgments all throughout the different courts and tribunals of Australia. Precedent is probably the core principle underlying the legal system. Precedent is a principle that says the rule or reasoning used in a previous judgment should be relied upon when the next similar case comes before a court. So if two parties have a dispute and that dispute is similar to one that came before a court at a previous time, then the court should follow a similar approach in terms of its reasoning and reach a similar result. There are two types of precedent that we normally talk about. One is binding precedent. This means lower courts must follow the decisions of higher courts in the same jurisdiction. So in New South Wales, the New South Wales District Courts must follow the decisions of the New South Wales Supreme Court. Persuasive precedent is when a court within one jurisdiction looks towards a decision made in another jurisdiction. So, for example, those New South Wales District Courts, they don't have to follow the decisions of the Queensland Supreme Court or the Victorian Supreme Court, but they can look to those decisions and they would consider them persuasive. So they're important to making a decision, they can be influential, but they don't have to follow them, so they can decide the case differently. In order to understand how precedent operates, you need to understand the court hierarchy in Australia. If we break it down to its simplest form, there are 4 levels of the court hierarchy in this diagram. We start at the bottom with local courts, also known as magistrates' courts. There are many of these throughout each state and territory, and they deal with the bulk of each state's caseload. So these are things like drink driving offences, shoplifting, and a whole range of more minor offences. As you move up the ladder, you get to district courts. So these are a bit more like regional courts. There are still quite a lot of them, but there are fewer than local courts, and these deal with more serious criminal cases. These hear most of jury trials for sexual assaults, robberies, and more serious offences like that. When we move up into the Supreme Court, then we're talking serious criminal offences or financial disputes involving large amounts of money. And finally, we have the High Court at the top of the hierarchy. The High Court is the highest court in Australia. Once an appeal is made to the High Court, there's nowhere else to go. So because of this, the High Court has quite a special jurisdiction. It hears constitutional cases, other cases involving disputes between the states, or other matters of public and legal significance. So you can see here that jurisdiction doesn't just mean that courts operate in different geographical areas like different states or regions or local areas. For courts, jurisdiction also means the authority to hear different types of cases. So local courts hear cases of a certain level of seriousness, then we move up to the district courts and they hear different types of criminal offences and financial disputes involving larger amounts of money. Those requirements are increased again when you get to the Supreme Court. And then the High Court requires special leave to appeal, so special permission. And like I said, it involves questions of constitutional or other legal significance. You can find case law in some of the same places that you find legislation, but it's a little bit different. So AustLII is still a really good source for case law, like we discussed in the previous chapter for legislation. Otherwise, you might use a database like LexisNexis, which your university library should have access to. There are also sources on the internet like Barnet Jade, or the court websites themselves where you can find individual judgments. Once you find case law via any of these sources, there are a few things to keep an eye out for. The citation, as with legislation, is really important and tells you the basic information about where the decision was made and who the parties were. Next, you should look out for the catchwords. These are keywords at the top of the judgment that will tell you what the judgment is about. And then there are the material facts and the ratio decidendi. This is really what you're reading the judgment for. The material facts are simply the important facts of the case, so this helps us determine, according to the doctrine of precedent, whether a future case should follow the same reasoning and reach a similar result. The ratio decidendi is the reason for the decision, so this is the judge's reasoning that should be applied in future cases. Here's an example of how to cite case law. We start with the two party names, in this case Thomas and Mowbray, And we say Thomas and Mowbray, even though there's a V, because the V stands for versus, as in the two parties are versing each other in the courtroom. In America, it would be more common to say Thomas v. Mowbray, but in Australia, we'd say Thomas and Mowbray. Next is the year, here 2007, and in rounded parentheses. And I bother mentioning that because there's another type of citation called medium neutral citation, which we look at in the book, which uses square brackets. Next is the volume number. Then there's the law report, in this case the Commonwealth law reports, and there are different abbreviations for law reports in different states. And then finally the page number that the judgment starts on. So to recap the key points from this chapter, case law refers to judgments published by courts. Precedent means that courts must apply the decisions of higher courts in previous similar cases, and you can look to the court hierarchy to work out which precedent is binding and which is merely persuasive. In relation to courts, jurisdiction means not only the geographical area in which laws operate, but also the power of courts to hear different types of cases. So the local courts hear one type of case, the district courts hear more serious cases, the Supreme Courts hear more serious cases again, and then the High Court finally hears constitutional cases and other cases of public significance. Finally, some discussion questions to get you thinking more about case law and practice finding it. So firstly, can you find a copy of this case, Alkateb and Godwin, 2004, 219, CLR 562? And after reading the catchwords, what do you think the case is about? Second, what are the different levels of courts in the court hierarchy? What types of cases does each court hear? What's the difference between binding and persuasive precedent? What are the two main things you should look for when reading a judgment? And what is jurisdiction and why is it important to case law?